Hi and welcome to our latest webcast. You're here with Lewis Izzo, Managing Director of Sydney Workplace at Australian Business Lawyers and Advisors. And with me today is Sophie Wish, one of our senior associates in the workplace team. Sophie, welcome. Nice to have you here.
Thanks for having me.
Hi everyone. We've got quite a jam-packed agenda in some ways today because we're going to, and I might just bring it up, we're going to start with a bit of an introduction for everyone in relation to JobKeeper 2.0 or 2.1. We actually have up on the slide. I think most people refer to it as 2.0, but we can call it 2.1 as well.
It changes every week, so call it whatever you like.
Exactly.
It's the next phase.
The next phase of JobKeeper. We're also going to talk about the Fair Work amendments that are taking place and might give you a little bit of an insight as to where we're seeing industrial reform head in relation to the Fair Work Act generally. We're then going to take a particular focus on managing performance and attendance and talk about what kinds of things you should be thinking about during a performance management process, particularly during the current pandemic. We're going to talk about managing leave a little bit, handling terminations of employment, and then we have a whole heap of questions. So in relation to questions, some people have already sent in questions that we're going to address, but we have plenty of time that we're going to allocate to answering questions that you might have during the course of the webcast. So please send them through. We have the iPad ready to go to answer them as we go, and if your question doesn't get answered on the air, then we'll follow up after anyway. So that's kind of the next hour. We might get underway.
Let's go.
So I'm going to do a little bit of the talking first off, just to give everyone a little bit of an update in relation to JobKeeper and where we've gotten to. What we've gotten to in terms of the payment subsidies is that the current JobKeeper 1.0, if I can call it that, is due to expire on the 27th of September. And from 27th of September, the new 2.0 JobKeeper, which is going to take place, will require employers to requalify. And to requalify, you will need to demonstrate that in the previous quarters, so for December, that in the previous September quarter, you satisfied the decline in turnover test, which is either 30% for most companies, but for big multinationals or ones with very large turnovers, it can be as high as 50%. So you have to re-satisfy that reduction in turnover test. That's something that wasn't a feature of the old JobKeeper. Under the old JobKeeper scheme, if you qualified for the payments once, you then could access the payments all the way through till September. Not so anymore. If you're going to access December quarter subsidies, you need to meet the turnover test for the September quarter. That is your downturn in turnover in September must be, say, 30% less than it was in September 2019. And if you want to access the JobKeeper subsidies in March, then they will look at the December quarter. So that's the starting point. The wage subsidies have changed slightly as well. I'm not going to take everyone through the changes in the amounts because it's been known for some time now, but broadly speaking, the subsidy that you qualify for will depend on the number of hours of work that relevant employees were performing as at 1 March 2020. And you'll see up on the table the various subsidies that are in play. There's different subsidies for the December quarter as opposed to the March quarter. And again, what you'll see is we're talking about a tapering off process. Initially, it was $1,500 a fortnight under JobKeeper 1.0. We're slowly starting to move to a lowest level of subsidy to try and get employers off the sugar hit that the government's been giving.
Yeah, there's really a point that they're trying to get people back to work as well. Slowly and in accordance with the health orders, but certainly lowering the amount that people might be receiving if they're not at home and starting to return back to the workforce, maybe for 2 days or a day. That will certainly help. Yeah,
and to try and get people to get back into business as usual. In relation to employers that continue to qualify for JobKeeper, the existing flexibilities that have been introduced into the Fair Work Act will remain. So that is, there is an ability to stand down employees where they can't be usefully employed, stand them down for a portion of their working week or in fact their entire working week. There is an ability to direct employees to work elsewhere at different times or on different days. There is an ability to request employees to take annual leave, and they cannot unreasonably refuse those requests, provided that the request doesn't result in them having less than 2 weeks annual leave left in their balances. All of those directions remain in play, or all of those flexibilities remain available. Please remember that there is a consultation requirement that applies to exercising those rights, and that is of 3 days. You have to consult before issuing any directions. And also, any directions that are issued must satisfy an overarching reasonableness test. They must be reasonable in the circumstances. And if you don't meet those types of requirements, the directions or annual leave requests can be challenged in the Fair Work Commission, which has the power to arbitrate any disputes. So that entire flexibility regime, if I can call it that, remains in place and will continue to operate from now until March for those employers continuing to access JobKeeper payments. Now, we have a new regime that has been introduced into the Fair Work Act for what we call legacy employers. Now, legacy employers are employers who once could access JobKeeper, so you were able to access it for a period, most probably from March to September, but now no longer qualify. In those circumstances, if your revenue remains, or your turnover I should say, remains at least 10% less than it was in the preceding quarter, you can access a legacy regime in the Fair Work Act, which gives employers certain flexibilities in terms of the directions they can give to staff. Now, in order to meet this kind of legacy employer threshold, there's a couple of things. The test is the same as the JobKeeper test, except the downturn is, as I said, 10% instead of the 30% or 50% thresholds under JobKeeper. And secondly, you will need a certificate from a qualified taxational financial advisor, and we'll come back to that in a moment, certifying that you satisfy the test. And the certificate needs to be in relation to the quarters ending in 30 June, in 30 September and 31 December. You'll see all of those listed there to demonstrate that you have suffered a particular ongoing decline. And the certificate needs to be provided either by an external and independent financial services provider, so you're talking about an accountant, tax agent, so on and so forth, or for small businesses, it can be satisfied if you make a statutory declaration. But you must satisfy that 10% decline test. You must have a document in place, whether it's a stat dec or a certificate from your relevant financial advisor, before you can access the additional flexibilities.
Lewis, I just read this morning that while there's no prescribed form for the certificate, that the Fair Work Commission is planning on releasing some sort of template form. So it might be useful to know that. Maybe you could send that to your accountants and
absolutely. I mean, this whole concept is quite novel. So for those people who are going to their accountants, they may not have templates readily accessible. So to the extent that the Fair Work Commission's making templates available, should easily be able to access them. You could do that certainly by contacting the Commission's website or through our office. We can certainly make that available. The final point about these legacy employers is the flexibilities that are available. So it's a case of same but different. And what I mean by that is many of the flexibilities that existed under JobKeeper do remain. Things about different work locations, things about being able to request people to work at different times. But the important one, or the important change, relates to reduction in hours. You can now no longer reduce employee hours entirely. You can only reduce their hours back to 60% of what they originally were, or that is, implement a 40% reduction in their total hours, and you can't do any reduction beyond that. You'll also need to consult for 7 days as opposed to the 3 days that currently applies. So I think if you are taking advantage of JobKeeper flexibilities at the moment and want to move to this new regime because you don't qualify for JobKeeper anymore, it's very important to check whether the flexibilities you are using are still available because there have been some changes. But 2, you also need to reissue your directions. The directions that were issued previously will not be valid past 27 September. You'll need to reissue them under the new legacy employer regime. And so it's important to bear that in mind as well. That was it. It was a quick 10-minute snapshot of what we've seen in terms of the changes with JobKeeper. I might just borrow another minute of everyone's time to update everyone about the industrial reforms that are going on. You may or may not be aware that a group of unions, employer organisations, the government have been meeting to talk about possible long-term industrial reforms to try and help kickstart the economy and address kind of some pain points in the industrial relations system. Those discussions have been perhaps a little bumpy in the sense that there's been progress and setbacks. There's some interesting press today about some particular employer groups blowing up about deals being done outside the working group process. I think what's safe to say is that those groups are starting to reach their conclusion and that there's some hope for some levels of reform, particularly around key areas like definitions of casual employment, particularly around perhaps some flexibility for industries that are particularly in need, whether that's restaurants or hospitality. There's a hope that there'll be some changes that can be announced shortly. And so I think it's a case of watch this space, particularly if you're interested in casual employment, if you're interested in the restaurant or hospitality sector, or if you are participating in enterprise bargaining. Those are some of the key areas where it's likely we may see a deal of some sort or reform of some sort in the not too distant future. So stay tuned for that, and we'll certainly be updating clients and our distribution lists about that. Sophie, we're managing performance in the COVID age.
Yeah, look, it's funny because managing performance and actually attendance to some degree has always been an issue for employers. It always comes up as something that we're all dealing with on a day-to-day basis. It's just we're now dealing with COVID and performance, and it's that much harder to manage, supervise, speak with your employees, particularly if they're working full-time from home. So we wanted to talk a little bit today about some of the considerations that you should be thinking about when performance managing people during this kind of working from home COVID time. Some of you will have staff that have started returning to the workforce, maybe in a small capacity, maybe they're back full time, but you might have sections of your business or your business entirely that's working from home. And that's a completely different working environment for your employees. It's not like being in an office. They may not have contact with other people very often. You're learning to use a whole lot of electronic devices like Zoom or Microsoft Teams to have your meetings. And there's also additional pressures at home, things like childcare and responsibilities. Maybe your employees live with their elderly parents. There's a lot of things, maybe they got 5 flatmates. You know, there's a lot of issues that can come about with people working from home. The main thing with performance management though is I think you're naturally going to have lower levels of supervision over your employees and just less contact. You know, some businesses that I've spoken with recently are doing an amazing job of keeping in touch with their employees, having these group conference calls, having group Zoom meetings. But, you know, there's something to be said for also individually contacting your employees and individually speaking with people, because not everyone's comfortable speaking in a group environment. You've got a lot of introverts.
And I think this is the issue, is that the day-to-day contact that might take place usually in an office environment in particular is not happening. And unless people are making the effort to pick up the phone and call employees, just the feedback is not at the level it maybe once was.
Yeah, and look, one of my concerns about managing performance, you know, if you take a hospitality environment or a retail environment where you'd ordinarily turn up for work, you know, any kind of constructive criticism or performance management can often happen on the fly. You know, it happens while you're in the workplace or you're reviewing a document and Lewis tells you to fix it and you don't take it too personally, but, you know, you move on and you learn from that. That's much harder over an internet call. It comes across as much more aggressive, it's much more serious than it needs to be. So those day-to-day performance management issues are turning into a bigger deal because they're happening online.
And so I think, Sophie, the challenge for employers is, well, if you are still conducting this type of process, what do we think are steps that employers should be taking to try and to demonstrate that they're accommodating this new world order? What can people be doing?
Yeah, look, there's definitely ways that there's things you can do to accommodate this new kind of world that we're having to performance manage in. So one of the main ones would be if you've got any performance improvement plans in place already. If you don't, put them in place, but if you've got them in place already, have a think about whether or not you might want to extend the time frame. It might have been that you put a performance improvement plan in place in March and it was only meant to go for a month or two. But if you haven't had any physical contact with that employee, or you're only calling them once a week via Zoom to check in, it might be worthwhile extending that plan so that the employee's got more time to comply, and so the employer looks more reasonable. Another one is just getting things in the diary. You know, a lot of things are happening online, so if it's not in the diary, it's not happening. So keep a record of meetings that you're going to have with this person, diarise things. If your performance improvement plan says you'll meet every 2 weeks, put it in the diary and do it via Zoom.
And I think that serves two purposes. One, it ensures that the meeting or the discussion happens, but two, you have a documented meeting. You have a documented objective piece of evidence that you can then go back to later on and say, no, I did meet with this person at this time. I know we weren't in the office. I know it's difficult to remember that we spoke, but we did because I have an Outlook calendar that confirms that we were meeting at this time.
Yeah, and look, that happens generally. If you're giving warnings or feedback and they're not in writing, you can't rely on that later. It's much, much harder to prove that a conversation happened, where it happened, what you said. If you're putting things in emails or you've got diary or calendar entries, it's much more reliable later on to show that you were following a process. And the last thing, which is particularly specific to COVID, is you need to be quite conscious about calling out and looking into any home-based pressures that your employees might be suffering from, and what you've done to accommodate these issues. So if there's a reason that someone's struggling to comply with your performance requirements or the performance improvement plan, what is it? Explore that. Is it because they're having difficulty working at home with children? Is it because they have 5 flatmates and everyone's on calls at the same time? You know, maybe they'd benefit from being allowed back into the office a day a week, or something else to make sure that you're seen to be accommodating those issues.
And I think this has two benefits. The first is you might get to the core of an issue relating to the underperformance. It might not be just because the person wants to underperform. Most people don't. But there's some other pressure that is affecting them and how they're able to perform. And so you might actually be able to start exploring if there's ways to address that. But secondly, again, it's going to look very good if there is ever a claim that comes out of this, that you called out these pressures, you said, I'm conscious of this, and we're trying to give you additional ways of dealing with these challenges by, as Sophie said, you know, coming in or giving you different working hours or whatever it might be. If there's challenges there and you call them out and try and accommodate them, you're going to look much, much better from an outsider's perspective if the performance process ever gets challenged.
Yeah. Look, some of these things may not even come up until there is a claim, and it's only when the claim comes that the employee might say, well, I couldn't possibly comply with a 1-month performance improvement plan because I had these things going on at home. If you didn't know about them, there's not much you could have done to fix it.
Now, one of the other things we've talked about is probationary periods, well, particularly for businesses that have some of their workers at home or stood down. Do you want to just take us through that?
Yeah, look, it's interesting. The performance improvement plans and those kind of performance issues lead us right into having your employees on any kind of probationary period or minimum employment period, as you might be referring to it. As you guys know, larger employers have 6 months for their employees to basically be on a probationary period or a performance improvement sort of issue, so that you've got this period of time in which to assess your employees. The reason that matters is because if you terminate someone outside of that period, you're putting yourself at a much more increased risk of an unfair dismissal claim coming and being successful. You need to follow, 3 warnings before someone's dismissed. There's various other procedures that you need to follow follow once you're outside that time frame. So it's 6 months for larger employers. If you've got 15 or less employees, it's a 12-month minimum employment period. What's worrying us at the moment about these periods is that a number of employers are putting people on, say, an unpaid stand down for a period of a month or two. And there seems to be this kind of naive understanding that maybe that extends the probationary period, but that's not the case. So you need to be really conscious of these timeframes, whether it's 6 months or 12 months, that you're actually using that 6 months to assess whether or not this employee is right for your business and making that call before you hit that time frame.
Yeah, and so, I think the confusion arises because a period of unpaid leave usually does extend probationary periods, but if it's because of a stand down or a JobKeeper stand down, those types of mechanisms under the Fair Work Act, actually there's an express provision in the Act that says that service continues during those periods, and that's why it's very important that you bear in mind that, oh, hang on, this person's continuing to tick over.
In a practical sense, I think that's quite challenging. If you have had staff that have, say, been on an unpaid stand down for several months, I don't know how you're expected to have assessed their performance or their ability for the job.
Absolutely, but one of the things for employers is that you just need to bear in mind someone physically cannot bring an unfair dismissal claim in the first 6 months of their employment. It's a very different world after that. So even if you haven't had a great opportunity, you really need to use that time to make a gut call about where you think things sit, because the moment you get outside of it, yes, you have to follow a warning process. Yes, you have to ensure you have a valid reason for dismissal. All those issues arise. Look, I think the final thing on that, just while we're on probationary periods, it is very difficult to extend a probationary period. And we have lots of employers ask about this, and it's very difficult for two reasons. The first is the minimum employment period, where there's an exemption from unfair dismissals in the Act. It is static. It does not change. It's 6 months for big businesses. It's 12 months for small. No matter what you agree with your employer, you cannot change that minimum threshold. So unfair dismissal access is triggered the moment you hit those 6 month and 12 month thresholds, regardless of any extension you agree. The other problem is we have a lot of employers, even under a contract, saying, oh, we'll agree to extend the probation. If a contract sets out a probationary period, it's very difficult to change that without consent. You effectively need consent. And there's going to be a real question about the quality of consent you're getting when you're turning up and asking someone to extend their probationary period. What's the alternate option that they have? Is there an alternate option? If not, questions of duress might arise. So I always urge employers to be very cautious about extending probationary periods. But particularly from a statutory perspective, it won't change the unfair dismissal access.
So, one of the reasons that Lewis has been harping on about why it's so important pre-6 months or pre-12 months to make sure that you've made those decisions about your employees is because once you've hit that threshold, you just have to follow a proper process before moving to termination or any kind of disciplinary action for any of your employees. It's just so important, and it's so much more time consuming than if you'd taken the time to assess that employee's performance or their suitability for the job prior to reaching those thresholds. This process that's up on your screen, I like to call the golden arrow. It's not actually gold in our slides today, but if I can drill this into you as an employer, that every time you are performance managing, every time you're thinking about entering into a disciplinary process, every time you're doing an investigation or possibly leading to a termination, if you follow this golden arrow and these particular boxes that are on this arrow, it will put yourself or your business in the best possible position should a claim arise. So the very first box there is establish the facts. Let's say it is, a performance issue. You need to make sure you've got some kind of evidence or something factual that you're putting to the employee as to why their performance isn't up to scratch. Do you have a policy in place that they're not complying with? Is that what you're raising with them? Do you have specific performance criteria that they haven't met? If you do, are those performance criteria in a document? Are they in a policy? Are they in a sales memo that's recently gone out to staff? Are they in a contract? Once you've established what the particular fact is or the allegation, the most important thing is you've got to put that to your employee. So it's not fair if they don't know what the issue is. How are they possibly going to have the opportunity to respond to that in a fair and reasonable manner?
And putting the position to the employee means you have to give a level of specificity about the allegation so they understand what is being alleged. And whether this is conduct or performance, they need to actually be told specifically what is an issue. You can't just say you're underperforming or, oh, look, generally you haven't been up to our standards. You actually need to particularise what it is that has been deficient, and that's what they need to respond to.
Yeah, and look, if you generalise too much, oh, you're underperforming, it's very challenging for the employee to work out exactly what they've done wrong, but it's also challenging for them to improve. Because if you were specific about that and you said, well, you hit these sales marks last month, but the criteria are that you need to be hitting these particular targets, or you need to be sending a certain amount of emails every afternoon and I wasn't seeing you sending those, that's much more specific and it gives the employee an opportunity to improve. Probably, this could probably be the most important part of the arrow, is once you've put those facts or those allegations to the employee and you're giving them a chance to improve, you also need to meet with them and allow them an opportunity to respond. Now, meeting with them might be challenging in today's environment, so if you're not meeting with them in person and you're running through this process online, have a Zoom meeting, diarise that you're having a meeting with this person. You can also write to them in regards to whatever the facts or the allegations are, and let them know that if they're more comfortable writing back to you, they can write back their response. But it's really important that they're given an opportunity to respond to whatever it is that you've put to them. Next, you'll need to make sure that you've considered any kind of response. Don't just brush it off or sweep it under the rug. You actually need to think about what it is that they've responded and what they've said. So I'm trying to think through a scenario for you. Maybe performance management is a good one. If an employee is given an opportunity to respond to why they've been underperforming, it could go anywhere, but by way of example, one response could be denying it, saying that it's not happening, that those targets were never set, that they never saw them. And then you could have an employee respond in a completely different way, which is they're very apologetic, they want to improve, there's all sorts of systems that they want to put in place to do better that they didn't realise. Maybe they even raise some kind of consideration that they're having trouble working at home because they've got childcaring responsibilities. So whatever they say, make sure you give yourself time, and that might be 24 hours, it might be 48 hours, but give yourself time to think about what they've said before you respond to them and let them know what your findings are. Lastly, you're going to have to make sure that you explain what the next steps are, what the next action is. So if they are going to improve on their performance, what plan are you going to put in place? What are you going to do next? If it's disciplinary, are they going to get a warning? Is it the last warning? Could it possibly lead to termination next? And of course, once you've had time to do all of that, take action. Do what you said you're going to do. If you've got a plan in place, follow the plan. If you're going to meet every 2 weeks, meet every 2 weeks. If this ends up in a warning or some kind of disciplinary action, then follow that through. And the only time that there wouldn't be this process going any further would be if it was ending up in termination.
Yeah, and I think just the last bit, you just do need to remember there's really 2 points of feedback. So one is when you're considering whether there are substantiated underperformance concerns. But if you're talking about more serious sanctions, termination, final warning, you should really be identifying to the employee that this is what you're proposing to do and get their feedback on that decision as well, particularly for termination. And we'll talk about that a bit later, but particularly in the termination case, they need to know this is what I'm proposing to do and have an opportunity to respond to that as well. Now, we do have a question that's come up in relation to some performance and working from home. And it actually covers across whether people can stay at home or not. So we might deal with that in a moment because I think we're going to talk about working from home in a second. So we'll get to that in a moment. Oh, here we go. It's right here. It's up on this slide now. So I might go through this slide, then I'll come to the question. Returning to work. Right now, whether an employee can be compelled to return to the workplace really depends on the state in which you're in. If we take two states by way of example, our two most popular states, in New South Wales, an employee has the right to work from home. They must be allowed to work from home unless it is not reasonably practicable to do so. Sorry, I got it out in the end. What that means is employers can really elect to work from home unless you can demonstrate that that's not feasible, that's not practical. In Victoria, it's the other way around. In Victoria, it's not about their election. They must work from home unless it's not reasonably practicable to do so. So there's a mandate that people must be at home. Obviously, Victoria's in a particularly strong lockdown, and they're only allowed out if it's not possible to work from home. And I suppose the question then becomes, well, what happens if we're having an issue? And this is where the question arises. So we have from Michelle, what about if one team member is not doing what they are supposed to at home? Our office is set up so that staff can work from the office full time. However, we're currently only working 2 days a week in the office on a rotating basis. This one staff member is not working when they're at home to the same level as the other team members, so I've asked them to return to the office full time. Well, Michelle, you have a variety of intersecting issues there. You have someone who's demonstrated a lack of productivity when they're not in the office. You have, I'm not sure which state you're in, but let's say you're in New South Wales or Victoria. You have work from home orders that are compelling you to operate in a particular fashion. And so what you'd really need to demonstrate is that the productivity hasn't just dropped a little bit. You'd have to demonstrate there's some material shift in the way the person's been able to do the work, such that it is no longer practical for them to work from home. And you'd need to satisfy that test in order to bring them back or to compel them to come back. The other option is to say, okay, well, I can't get around the stay-at-home order if I'm in Vic or the public health order in New South Wales, but that doesn't mean I can't performance manage this person. And so you'd go through the process that Sophie's been talking to you about in relation to performance managing people at home, and you'd talk to the person about their lack of productivity, and you'd talk to them about the kind of drop-off you've noticed, and either have an informal chat or potentially, once you've had that informal chat, a more formal documented process that might lead to a performance improvement plan of some kind.
I mean, that makes sense right now, but I do think we will move into a world where a lot of office workers, a lot of people who were, encouraged to stay at home during this time in New South Wales and Victoria may want to stay there. They might want to retain this kind of flexibility. And what's going to happen with those types of employees if we're not seeing the same productivity or the same work output as their colleagues at home?
Yeah, and I think there's a few things to think about here. I mean, the first is, for as long as the health orders are in place, it's difficult to bring someone back if generally your workplace has demonstrated it's working from home. I don't think you can point to a 5 or 10% drop in productivity and say, aha, it's not practical to have you at home. You'd need a kind of material shift.
It's quite challenging for a business that perhaps isn't output based. Lawyers, accountants, there's people who put their time down for how much work they do each day. So you've got a record of who's working 7 hours, who's working 2 hours. PR puts down, quite a lot of PR agencies put down what work they did each day, but not every business has worked with that kind of system.
No, and I suppose then you get into the other areas of law that intersect with this. We have the right to request flexible working arrangements under the Fair Work Act. Now, that's the starting point. If your employees start to say, well, I want to work from home for a significant period of time, they might put that request under the Fair Work regime. Now, as an employer, you have to respond to that request. You've got to respond in writing. You've got to respond within 21 days. And you can only refuse on reasonable business grounds. Now, not everyone has these rights. There's certain, in particular, certain categories of employees over a particular age with carers' responsibilities that are able to access these flexible working arrangements. But as an employer, you need to ensure you're complying with that Fair Work regime. Now, I've said this before, and I'm happy to say it today, the Fair Work regime is a little bit of a toothless tiger, because once you've declined a working from home request under the Fair Work regime, provided you gave that response in writing within 21 days, citing operational reasons, there's basically no ability to challenge that in any court or tribunal. However, having said that, there are anti-discrimination laws that do protect certain categories of workers, and primarily in this case we'd be talking about people with family carers responsibilities. If they can't leave the home for some reason and they can establish their ability to work from home, then there might be an indirect discrimination claim that they might be able to bring that tends to demonstrate that, hang on, you're imposing a requirement on me that I'm less able to comply with the rest than the rest of the workforce, and is not reasonable in the circumstances. Now, if they're able to get that type of argument up, you might have a problem from a discrimination perspective. So there's a whole heap of, or a myriad of different laws that are peppering this area. And I suppose where we're at now is public health orders and stay-at-home orders are making it pretty easy for employees to stay at home if it's possible to work from home and practical. But even once they dissipate, if employees have established that they can work from home quite well, you're going to have to start to build a narrative and a logical and rational basis why you need them back in. And I think there's going to be a huge amount of work for employers to do over the coming months if that's a direction they want to head in.
Lewis, I'm just going to ask it because I know that people are wondering. Do you think there will be a sort of drop-dead date where these public health orders are just removed entirely and it's everyone go back to business as usual on Monday? Because as an employer, if that is what happens, that's going to be very challenging to suddenly go from this workforce that might be predominantly at home to, okay, on Monday we're all going back in.
I think the changes to the orders, what we've seen in the past, have been the notice period's about 3 or 4 or 5 days. It's not significant. There's a lot of conjecture about when this particular order about working from home might change. I think my personal suspicion is that until we get a vaccine, we've probably got an order like the New South Wales one for some time. Obviously, Vic is going to be relieved shortly. We're hearing some very positive news out of Victoria today. But I think the notion that people may be allowed to work from home where practical, I think that's going to be around for some time. We've got another question from Anthony about sporadically absent employees and performance management. They take every second Monday off. Supplying a medical certificate, can't have zero, but have zero leave. You know, how can they be performance managed? I think there's a few things about this. You're starting to move into the world of absent injured workers, which is its own webcast in and of itself. I think the starting point for any sporadically absent employee is to performance manage them on the notice and evidence requirements. Start putting in a strict regime about notifying you within a certain period if they're absent, about providing evidence that would satisfy you for the reason of the absence, etc. And put in a very strict regime about notification and evidence. That tends to either get employees back into line, or if they don't, you can start disciplining them for not complying with your regime.
I've had a lot of clients probably in the last month or two, particularly calling with regards to employees taking a lot of sick leave. Some of those employees are on JobKeeper, and we'll come to that later, but taking a Monday and a Friday or taking a full week of sick leave, and just how employers should go about managing that while still allowing their employees to take their entitlements. I mean, if somebody's sick, they're entitled to take their personal leave. The problem, I think, has arisen because a lot of these employers perhaps don't have a leave policy or something to look to that they can point a finger at and say, see, in our policy, you have to provide some kind of certificate or you have to provide some kind of evidence if you take personal leave or annual leave on a Monday or a Friday, or it's happening last minute and you're not applying for it properly. I found that putting a policy in place has been really helpful.
Absolutely. And I think just be conscious, if it's a short period, if it is a week, if it's sporadic few days, employees have the right to take that leave, and there are protections. You cannot dismiss people because they're temporarily absent from work, which is an absence of less than 3 months in a year. So it's really about using those other levers initially, and then if they're really absent quite regularly, you might start looking to get them medically assessed about whether they can perform the role. Managing leave, that's a helpful segue.
Yeah,
Take it away, Sophie.
It's become very apparent that there are quite a lot of issues around both personal leave, but in particular, this slide's about annual leave. So what we've really noticed is that a lot of employees are not taking leave. There's border closures, people can't travel, no one can go overseas. So where you might have seen your staff bank up their leave and take, say, a 4-week holiday overseas, maybe they want to do a European summer, or maybe you had employees that would always take 2 weeks in winter and head up to the Sunshine Coast, Queensland's closed their borders. So a lot of employers are seeing their employees' annual leave balances just escalating. They're quite big, some of them are substantial, and that can have significant consequences for your business. One of those consequences is employee related, which is if people aren't taking leave, and they're either working really hard, which is why they're not taking the leave, or there's not a lot for them to do, they can get burnt out. And that's always been one of the reasons why annual leave exists in the first place. That's always been one of the reasons why you want employees to take their annual leave and not just be paid out for it. And of course, it can have significant financial consequences if your employees aren't taking their leave, because the liability's racking up for you. I know that there's certain banks who, when your leave liabilities get too high, they won't lend you certain amounts of money. And so you might find yourself in a position where you need to address this huge leave balance that you've got sitting on your books and how you can get that down. So we've come up with a couple of bullet points for you today as to how you might be able to lower those annual leave balances if that's a problem for your business during this COVID time. I will say, be positive, Christmas is coming, and whether or not we're allowed to travel, it's highly likely that you'll at least be able to encourage your employees to take a little bit of time off then, spend some time with the family. If not family this year, then maybe friends. But things are looking positive in terms of travel around that Christmas time. So some of the ways that you can address the leave balance and try to get it down is, of course, directing employees to take annual leave. If they're award or agreement covered, you can only direct it in accordance with what that EA or what that award says you can do. Generally speaking, across the board, it's pretty much a direction only for 2 reasons. One would be an annual close down, so say a period of time at Christmas or New Year where every year that's when the business closes down for a period of time. There might be restrictions around how long you're allowed to close down for, or whether or not you're allowed 2 close downs in the year or just 1 at Christmas. So always read your award or your agreement if that's what applies to your employees. The other is probably more common, which is if someone's got an excessive amount of leave in their balance. Everyone always asks, well, what does excessive mean? Generally speaking, if the employee's award or agreement covered, excessive means 8 weeks of leave. Now, I know some of you, or I can hear some of you being like, 8 weeks, that's heaps, but that's the rule. If their award or agreement covered, it is what it is.
Well, certainly in the award space.
Yeah.
I mean, you might have differences in an EA, but as I've said, that the awards have kind of moved to that number. And I think so you just need to bear in mind that you have no flexibility except what the EA or award gives you in that space, and you're effectively governed by those documents. If you're not EA or award covered, things open up considerably. You can direct an employee to take excessive leave, provided it is reasonable in the circumstances. And that's great, because what's reasonable will depend on the circumstances of every case. But if you give a lot of notice, if it is for an annual close down, and that's something that the business typically does, then that may well be a reasonable basis to direct someone to take leave. Again, if you give a lot of notice and they have an amount that's excessive, might not be 8 weeks, might be 4 or 5 or 6. Provided you're giving notice, you're not draining them their whole balance, you're probably going to be able to do it. So for award and EA-free employees, much easier. For award covered and EA covered, governed absolutely by your instrument.
Regardless, one of the limitations on getting people to take that excessive leave is that you always need to maintain 4 weeks leave as a balance in that employee's balance of leave that they have. So you can't go below that threshold. Another interesting thing would be, we're talking about leave in big chunks because that's most, you think of that automatically as being most helpful to you, 2 weeks of leave here, or 2 weeks at Christmas, or 4 weeks to go on an overseas holiday. But have a think about if you're in a position to be able to allow your employees to take a Monday or a Friday, because that does add up. And if they can take a day here or a day there, and they can start having these long weekends. That will help you with employee burnout, but it will also slowly lower your annual leave balance.
And then obviously don't forget that for those that do have access to JobKeeper, there are the leave provisions in the JobKeeper laws. We've got another question we might briefly deal with about, again, this interaction between sick leave and performance. It seems to be a common theme from Bronwyn. We're back working full-time in the office. However, when people need to go home sick, they say they will work from home as they have no sick leave entitlements. What can we do? That's a challenging one. I think the starting point is, are they fit to perform their role? Now, if they're not fit to present for work, then the ordinary consequence is they take personal leave or unpaid leave and might need to provide evidence. I think that's the starting point. If what the evidence is saying, if what the employee is saying to you is, well, no, I'd just like to prefer to work from home today, then I think you have to assess that based on any work from home request ordinarily. And if the reason they're doing it is because they're sick, you might say, well, no, I'm not comfortable with that. That's going to impair your ability to get better. I actually think you should take leave. If, on the other hand, the employee is saying that they're actually well enough to work, if they've disclosed they're sick, but all of a sudden they're saying they want to work, I think that's an example where you might say, well, look, I've got concerns about this, and until I'm given medical certification that you're fit to work, I won't be able to allow you to work. So you can actually turn the tables on them a little bit in that space, and I think there's an ability to be a little bit more robust around that if you've got genuine concerns that they're not going to be working at home.
What we have found in the last few months, though, which is challenging to deal with, is a lot of employers have either put a policy in place or just a general guidance or a rule that if you've got a sniffle, if you've got a headache, if you've got diarrhoea, like there was a list of things that possibly could be symptoms of COVID that you shouldn't come into the workplace. Now, a lot of people with a small headache or a scratchy throat might feel fit to work, and that's created a bit of an issue for people because
absolutely.
They want to work, they just need to be at home.
And that's a good point. If you're forcing the person not to come in, then you can't all of a sudden put them on leave. If you're telling them not to present for work, then really you're going to have to be paying them for the period unless you can determine that they're not fit. So it's a difficult area, but I do think if you have someone self-presenting as being sick, they've kind of disclosed that they're unwell, they're not able to come in, then I think it's legitimate to start asking questions about, well, can you legitimately be working from home? Is it going to pose a risk to your safety? Because you really should be resting, and you might try and deal with it that way. But
it doesn't tend to be the one-offs either. You start to see a pattern. It's every Monday and Friday, or it's the same person taking personal leave every week.
Absolutely. Now, terminations of employment. We're back to the golden arrow. I think just the short point in relation to this is absolutely, if you're going to be engaging in any termination process, you have to do everything Sophie said before. And again, if I can reinforce that, it's important that not only do you put your allegations about what's happened to someone, let's say it's a performance issue that has not improved, you need to put all that to them, but also put to them that having found that this underperformance is not improving, I am considering terminating your employment. Very important they have that knowledge.
We also get that it's a long process. We get that it's exhausting. We understand all of that. But the problem for us is too often we see successful unfair dismissal claims from employees where the reason for the dismissal might be justified. Perhaps the person's stolen something or something else, but the process that the employer followed to get to the dismissal wasn't fair. And that's just following this arrow. Yeah,
absolutely. Just a quick one on dismissals. There's two things that will always be looked at. You need a valid reason for dismissal, which is going to be based on conduct or performance. A valid reason is a reason that's sound, defensible based on fact. It can't be what the courts call capricious or whimsical or fanciful. It must have some substance behind it. And then you get back to due process. Was effectively the golden arrow followed? So they're the two things the Commission will look at. That applies just as much now as it did before. In fact, there was a case that just confirmed this the other day. Allen and Dapto Fish Feast, I assume from down in Dapto, just near Nowra. The case actually involved a redundancy where there had been no consultation, and the Commission had significant concerns that the employer had basically exited this employee at no notice from the business. And Commissioner Reardon made an interesting point where he said the pandemic has resulted in an unprecedented upheaval of global labour relations. So it's gone big in terms of the kind of terminology he's used. But then he said, whilst workplace restrictions and industrial principles have been appropriately relaxed during this period, the underlying notion of a fair go has been maintained. The applicant did not receive a fair go. He was entitled to be consulted and he wasn't. And so the applicant won the unfair dismissal case. But the thrust of that is really saying these laws remain, you still need valid reason, you still need due process, and overall employees need to be given what the Commission will call a fair go. And so that's just a bit of a reminder about that.
So can you terminate a casual that hasn't worked since March due to COVID? Look, that's challenging because they are a casual by nature, and it may be that had COVID not have happened, they wouldn't have had a huge amount of shifts between now and March. But one of the things I'd want you to think about is whether or not you nominated that particular casual if they were long-term. Perhaps you nominated them for JobKeeper, and that's what's bothering me, because I had a case the other day where a casual had been nominated as a long-term casual for JobKeeper, was receiving the JobKeeper payments, but that particular employer is now not eligible for the next round of JobKeeper, and the employer doesn't have any work for this casual to do, so it's very apparent that they either terminate the casual and be upfront about what's going to happen next, or they simply stop giving this particular casual shifts. Look, at the bare minimum, they're going to need to notify them that they're not going to receive the JobKeeper payment anymore because the employer's not eligible. In terms of terminating that particular casual, look, it's always up to you. If there's going to be the possibility that there's more shifts on the books, maybe you leave them there. But if you're very sure that you're lucky to be getting work for your part-time and full-timers, I think it's more likely that you will be proceeding down the path of terminating a casual.
And one of the things here is, it's how long's a piece of string, but let's say a casual, let's say it's not the JobKeeper scenario. Let's say a casual just hasn't had shifts since March. There's a point at which you ask the question, are they still my employee? Now, the casual might say, it's dawned upon me today that I'm effectively no longer employed. That might start the time frame for their unfair dismissal application. I mean, at some point, if they've been regular and systematic for more than 6 months, they can file for an unfair, but they have a 21-day time frame to do so. And the question will be, well, when does that time frame start? When is the point of dismissal? And it can be quite
And have
grey.
they been regular and systematic? I mean, they haven't worked since March.
That's right. So all of those issues kind of feed into it. So it's not an easy one. I think we might skip this one because we talked a bit about forcing people to take annual leave. Can I terminate staff that are continually calling in sick while on JobKeeper? This is an interesting one. I take it we're talking about staff that are on the JobKeeper payments, so they're still getting payments even though whether they turn up or don't.
The most common scenario I've had with people calling in sick while on JobKeeper is an employee that perhaps only works 1 or 2 days normally pre-COVID, and then with the JobKeeper payment was receiving a much higher amount of money.
And so basically it's not worth their while coming in because they get the same amount of money each week or fortnight anyway. Look, very difficult if they're calling in sick, because the way you have to handle that is like any absenteeism issue. You go back to notification, evidence requirements. You need to make sure they're substantiating. So I'd start with those disciplinary processes and managerial processes, and really try and catch the employee not complying with your notification requirements. If they do and they're still calling in sick, well, they do have a right to be ill for up to sporadic absences of really up to 3 months. So there isn't a lot that can be done without risking an unlawful termination. If it does start to become quite significant, you might at some point look at having them medically assessed to understand if there's a reason, but the reality is they have a right to be absent from work for a period on a temporary basis, extending up to 3 months. So there's not a lot that can be done without exposing yourself to an adverse action, general protections type claim. We've got another question about wanting to understand JobKeeper enabling stand downs when you no longer qualify for JobKeeper. The short position is your stand down will cease being lawful from the 27th of September. So if you've stood people down, they have a right to return to their previous working arrangements from 27 or 28 September. And what that means is you can only stand someone down after that point if you meet the much more rigid Fair Work Act test. Now, the Fair Work Act test says you can only stand someone down if there's a stoppage of work. As a result of that stoppage of work, sorry, let me go back a step. There's a stoppage of work for which the employer cannot reasonably be held responsible. And as a result of that stoppage, the employee cannot usefully be employed. Now,
basically, we go back to March, April rules before we had JobKeeper. Were you able to stand down your employees then? Did you satisfy that test?
That's right. And so you need to show they can't usefully be employed, you need to show there's a stoppage, and you need to show it's for a reason you can't reasonably be held responsible. And that's what you need to satisfy before standing someone down. Can you direct employees on JobKeeper to do more shifts than their workload in order to match the amount they're receiving? It sounds, Sophie, like we're talking about a scenario where someone is perhaps receiving more money than they're used to. That's a difficult one. If they're a casual, they always have a right to refuse shifts. If you're trying to offer them greater numbers of shifts, they don't necessarily have to accept them. And if they're permanent, well, their hours may well be their hours and they're contractually determined, and if you're trying to increase hours, you really need to do that by consent.
Yeah, look, this was happening a lot in the hospitality industry because they had a number of employees on JobKeeper, and then, as we've had sort of peaks and troughs of businesses being able to open, particularly in New South Wales, there was the ability for these casuals to possibly do more shifts than they usually would, but a lot of them had university schedules or something else, and there's a reason why they can't work on Thursday and Friday. So if you are, directing them to come in and try and have them work shifts on days that they've told you in advance they can't do, you just have to live with the fact that they're getting a little bit of a windfall, they're getting a bit of extra money, and hopefully that money is spent in the economy, which was part of the purpose of JobKeeper.
Absolutely. So I think that's all we have time for today. Thank you for joining us, Soph. And
thanks for having us.
Thanks for joining us, everyone out there in the audience. I'm sure we'll be back with another webcast in about a month's time, so stay tuned and check out your emails, and otherwise enjoy the rest of your week.